I'm James, and welcome to another one of my videos. Today I want to talk about burdens of proof. But you've probably heard the term burden of proof, and it basically encompasses two separate concepts. One is who has the burden, and the second is what is the burden. Let me talk about the first one first. When you have a case, somebody is trying to prove something against somebody else, or it may be trying to be proved both ways. If you're asking the court to do something, you probably have the burden of proof. A great example is a criminal case, which is where you hear this the most. The state has the burden of proof. The state has to prove a person is guilty before they can be convicted and fined or sent to jail. That's the state's burden. A criminal defendant doesn't have to do a thing. They don't have to prove they're innocent. They don't have a burden to do anything. It's the state who has the burden. That's also true in CPS cases. The state is the one asking that the court do something. So the state has the burden. Now, I want to be clear here. We're talking about a basic case. A parent or another party in a case could have the burden on a motion or an affirmative defense or something like that. So there could be some aspects of the case where you have the burden because you're asking the court to do something. And there's some exceptions to that too. Because the statute, sometimes even if you're asking the court to do something, puts the burden on the state to show why not in a CPS case. But just so you'll have a general understanding, generally if you're asking the court to do something, you're the one who has the burden. CPS is asking to remove the children from the parent's home, CPS has the burden. CPS wants to terminate the parental rights, CPS has the burden. You run into my car and I sue you asking the court to make you pay my damages, I have the burden to prove it. That's the first concept of burden. The second concept of burden is how much do I have to prove it? How convinced do you have to be, judge or jury, to rule in my favor? That can vary dramatically depending on the situation. And the levels of burden range from very low to very high and everywhere in between. Most of them can come up in a CPS case. Let's talk about the easiest level of burden to explain. And that's called a preponderance of evidence. A way I like to describe it, because if you take the words literally, it's exactly the same thing, more likely than not. So if you have the scales of justice, you think of the two scales. If one side tips ever so slightly in that direction, that side wins. Or you can think of it this way. If it's 50% plus any amount, that side wins. Because that would be more than the other side. The evidence gives them more points, more convincing, whatever you want to call it. When a judge or a jury is weighing the evidence, if it weighs just even slightly, it doesn't have to be any much more at all. Now, some of you are probably already wondering, well, what if it's exactly the same? What if there is no difference? Then the person bringing the case or the motion or whatever has not met their burden because it's 50% plus any amount. 50.1 to 49.9, 50.1 wins. But if it's 50-50, that doesn't win. So that's preponderance. And attorneys always like to start with that because it's the easiest one to explain. One of the harder ones to explain, but there's probably been more time spent trying to explain this one than any other, is beyond a reasonable doubt. Now, you've probably heard that. Now, you may have also heard beyond a shadow of a doubt. That's Hollywood. That's made up stuff for TV and movies and things like that. That doesn't exist in the court. It's beyond a reasonable doubt. That's very hard to define. And criminal attorneys have lots of different ways, and they spend a lot of different times coming up with how to explain it. But you can know this. It is the highest burden. It's the highest burden there is. It doesn't mean no doubt. That we know for sure. A lingering doubt in the back of your mind is not enough by itself. It's not butterflies in your stomach. Many people, myself included, could never be 100% convinced of anything. I believe anything is possible. So you would have a very difficult time ever convicting somebody if it was that high of a burden, if it was 100%. Probably never would. And it was never an intention not to convict people who commit crimes. The intention, of course, is not to convict people unless you're very, very sure. So that's a very high burden. You've got your preponderance, which is, let's say, in the middle, since we're doing it like 50% plus. So we'll say, and then somewhere up here is reasonable doubt. It's very high. Now there's another burden which does not come up very often. There's very few situations, or relatively few situations, where it comes up. And the most common is actually CPS cases. And that's called clear and convincing evidence. And it is another very difficult one to define. It is more than preponderance. So 50% plus 1 is not enough. It's not as much as beyond a reasonable doubt. So even if you have a reasonable doubt, you could still rule in favor of, in this case, CPS. Because you could still find the evidence clear and convincing. It's somewhere in between. So, more likely than not is, if I had to say, I think they're probably right. When you think about it, probably means more likely than not. If you're saying probably, technically, we don't use language technically correct, but technically, probably would mean more than 50%. But that's not enough. So you can't say this CPS is probably right. It's got to be pretty clear, and you've got to be convinced. Even if there's a reasonable doubt up there, okay, maybe that's not enough to keep the judge or jury from terminating parental rights. But it's still got to be up there, and you've got to be very sure. That's the best way to define that. Now, really, those are what you need to know for the most part. There are some others, and I'll go over them kind of quickly because they're more for the attorney and technical things. Ordinary prudence and caution. That's a very low burden. And one of the areas where it applies today, but possibly not tomorrow, is the affidavit for the removal and the adversary hearing. As I said in my introductory video, the law changes fast. The Texas legislature meets every 2 years, and something changes in CPS law every year. And right now, and this is being filmed in June of 2021, the legislature is finalizing some fairly significant changes. But again, that's for your attorney to know, and for today at least, ordinary prudence and caution is affidavit and the adversary hearing, and possibly orders for participation after this year. So, but attorneys, if there are any attorneys watching this, make sure you look at the statute and verify. And I'll talk about that more in the later videos. And if we have the final drafts of the law, then I'll include them. But you'll want to look at those 2021 changes, of course, before the hearings. Now, the affidavit and the adversary hearing, well, the affidavit's done before attorneys are involved generally, so that's really going to affect the CPS attorneys more than anybody else, and the judges, of course. But for the adversary hearing, if you're going to contest it, then that's important to know. At most of the other hearings, the status hearings and the permanency hearings, although it's not clear, you can assume it's preponderance of the evidence. Now, what is it they have to show by preponderance? Well, that gets into the hearing itself, and I'll talk about those in videos. And again, that's something more for the attorney, though you may be interested in know just to have a better understanding of the system. Now, at the end of the case, if CPS is asking to be managing conservator of the child, meaning they're going to be the permanent managing conservator, they've been the temporary one up to the final trial, but if they want to be the permanent one without terminating the parental rights, well, then they have to prove by a preponderance of the evidence, which is the lower burden, because they're not terminating the parental rights. Taking a child away from somebody is significant. Saying you're not going to get to be the primary parent and the state is, that is significant. But terminating somebody's parental rights forever is much more significant. You're closing that door. That's where that higher burden of clear and convincing evidence comes in. One caveat: if the case involves an Indian child, and that's a defined term, which should have been noted long before final trial. If it involves an Indian child and the state wants to terminate, there is something additional that the state has to prove. This is in federal law. Most of this is state law, but this is in federal law. The state has to prove something, I won't go into the details, and they have to do it beyond a reasonable doubt. And it's similar to what they have to prove, or at least part of what they have to prove at the state level. But it raises the burden to beyond a reasonable doubt. There's lots of reasons for that, and in my video on ICWA, which is an acronym for Indian Child Welfare Act, I talk about that. And go into, of course, much more of the law for the attorneys and everything. But that's the only case, that's the only situation in which beyond reasonable doubt comes into play. So I hope that helps you to understand those terms, and if they come up in your hearing, to kind of get a better understanding. And when your attorney is talking to you, hopefully that puts you in a better position to understand. Thank you for watching my video again.